So with a crime of this nature, people naturally want answers. And so the real dominant feeling right now is one of curiosity, one of wanting to know not just what happened specifically, but why. So this is governed by Idaho Criminal Rules, Rule 11, and it specifically contemplates that you can enter a not guilty plea, a guilty plea, or if you refuse to enter a plea, then a not guilty plea will be entered for you. So that's what he essentially did in this case, is elect not to enter a plea. Actually saying the words not guilty can be a little bit adversarial, particularly in front of the victims' families. So it's a possible reading could be that this route was chosen to potentially keep plea bargaining options more open, but it's also possible that just as a matter of comfort, to be able to to have to stand up in court and say the words officially can be challenging. So I don't want to read too much in it from a strategic standpoint. I would just assume, however, this was the attorney's recommendation and that he followed it. It seems to me that the trial date was chosen to avoid a speedy trial waiver. We saw that Bryan Kohberger had waived his right to a speedy preliminary hearing, and that in hindsight gave the prosecutor time to convene the grand jury and then bypass that process altogether by getting the indictment. So it is possible this is a once bitten twice shy type of scenario, that he's not going to go ahead and waive again and give those opportunities to the state ahead of time. But that said, the feasibility of the defense being prepared to go forward on a trial of this magnitude by October the 2nd does seem pretty minimal. So I think there is a pretty good chance still that down the road we would get a motion to continue from the defense with a speedy trial waiver at that point. I think that especially because this case has taken on national proportions, it's difficult to suspect that you're going to find people in Boise who aren't just as exposed to the media coverage and so forth as the people locally. And I also think that with a small town, with a small community like this, a crime like this happens, it is a trauma for this community. It is something that they have to deal with. It's their burden, and it's also they have a need to heal from that. So I do think that oftentimes with events like this, there's maybe even a desire locally to keep it here because this affected them. And so there's a sense that they can and should be responsible for seeing it through to the end. We have not at this point gotten the notice of the aggravating circumstances that the prosecutor will have to file if he wants to pursue the death penalty. So a possible indication there is that there is some room being left open for plea bargaining to take place. Of course, can't say definitively one way or the other, but that is a possibility. And for Bryan Kohberger, the best way to get yourself in a position, if he is guilty, if there is a difficult case against him, is to bring everything that he has to bear against the state's case so that the trial outcome may not necessarily look like a foregone conclusion to the prosecutor. I think it's very possible that there is a significant amount of evidence that we have not heard of yet. And the main reason is because so much of this investigation took place after Mr. Kohberger was arrested, after he was initially identified. We've seen some bits and pieces come through that with search warrants and warrant returns being released and made public. So that in and of itself is indicative of just a lot of new information that is become available to law enforcement, to the prosecutor, but that we, the public, aren't going to hear about largely because of the gag order.